Most welcome everybody around the world, and thank you so much for making it to this very much awaited session by Iqbal. Who doesn't know Iqbal? I think we all know, and we admire you for not only for the best professionals, but I think the amount of pro bono work you do and public causes that you have taken up. I think that's something that I always look at you and consider you as an icon for all of us. Iqbal, I don't want to take too much time at the moment, but it's so wonderful to have you, and thank you so much. And we have close to over 500 registration for this session, and everybody is very keen on listening to you and me. But this is a very important subject, especially in this cross-border world that's causing issues with regard to the injunctions and stuff like that. So maybe I can ask Kshama to take it over from me for moderation, and as we go along, we'll continue to interact. Thank you so much. And once again, most welcome, Iqbal, and everybody around the world. Thank you.
Thank you, Mr. Desai. A warm welcome to our participants. The topic for today, anti-suit injunctions in litigation and arbitration, is special, both for the nature of this cross-border litigation strategy and the guest speaker we have with us today. Anti-suit injunctions are special species of injunctions. A party who is not willing to face oppressive and vexatious litigation in a foreign court can apply for an anti-suit injunction in its own country courts to restrain the foreign litigation. A party who has agreed to international arbitration can seek an injunction from its own country courts to restrain the other party from initiating or continuing the arbitration through an anti-arbitration injunction. When can parties or companies use this mode of litigation? How effective is this litigation? These are some critical points that we often deal with at NDA, and we'll be discussing today. It is quite challenging for us to introduce our guest speaker for today, Mr. Iqbal Chagla, sir. His name alone stands as an illustrious introduction. Senior counsel designation at the young age of 39 and 55 years at the bar, carrying forward a legacy that is unparalleled and most highly respected in the nation and in the legal fraternity. Mr. Iqbal Chagla, sir, is son of the highly regarded late Mr. M.C. Chagla, sir, Chief Justice of Bombay High Court. A warm welcome to you, sir, from all of us at NDA. Chagla, sir, obtained an MA in History and Law from Cambridge University. He was then called to the bar from Gray's Inn in England and returned to Bombay, where he began a long romance with the law. Having refused all inducements to move to Delhi, he preferred to be a leading member of the Bombay Bar. From the year 1990 to 1999, he completed 3 terms as president of the Bombay Bar Association. He also served as a member of the Executive Committee of the Bar Association of India and a member of the National Legal Services Authority, Delhi. Sir was offered a judgeship of the Supreme Court directly from the bar, a rare honor, which could most likely turn into the honor of being the Chief Justice of India in a few years. For personal reasons, he had to decline the honor. Sir has moved some courageous resolutions to preserve the integrity of the judiciary in the year 1990 and 1995, when the Bombay Bar sought resignation of a few judges who ultimately resigned or denied judicial work. Sir has appeared in international arbitrations and has advised on proceedings in foreign courts. He has given expert evidence on Indian law in the Southern District Court of New York and an Isle of Man court. He speaks at various seminars. In the year 2012, Sir was conferred an honorary PhD of Laws by Behrampur University in Orissa for retaining eminence in public affairs. A trustee of the Chief Justice Chagla Memorial Trust, the H.M. Sirvai Memorial Trust, and the Mehli Mehta Music Foundation. Plays golf with passion and has photography as an abiding hobby. Since this is a rare and important opportunity, I must share this experience. I had briefed Sir in the year 2013 in my first 2 months into law firm practice. This was a complex anti-arbitration injunction matter. Our client was seeking to restrain enforcement of an arbitral award in the USA. I had read the landmark judgment of Modi Entertainment versus WSG Cricket on anti-suit injunctions and very passionately briefed Sir on the judgment, how we can distinguish our case because the judgment was against our client. Sir listened to a young junior discuss the judgment for over 10 minutes. nodded in what seemed to me as approval of the points, and smiled in the end and said, "Keep 3 copies of the judgment handy, please." I went back happy and satisfied that evening to find by accident the next day that Sir had appeared for the respondent in Modi entertainment case. I learned 2 lessons that day: humility over one's own achievements and respect for the efforts of the junior most working on the matter. So we are all very grateful to have you today, and may I please invite you to open this session.
Words. I think the topics chosen for this evening discussion, I think, are 2 very interesting and I think very topical topics, if I may put it that way, regarding anti-suit injunctions and anti-arbitration injunctions. I'm assuming for the purpose of this talk that we're talking about anti-suit injunctions to restrain proceedings in a foreign court, as also arbitrations in a foreign jurisdiction. I'm not confining it, I'm not dealing with what may happen in our own domestic forum. The distinction must always be borne in mind between a forum non-application and an anti-suit injunction. Some principles may overlap, but it is to be remembered that a forum non-convenience is made to the court seized of a matter, while an anti-suit injunction is to a court where you are asking that court to restrain a foreign proceeding. This may be on the ground that it is offensive or vexatious, or because there is an exclusive or non-exclusive jurisdiction clause. It is curious that while anti-suit injunctions may have been granted or refused earlier, it was not until 2002 that for the first time the Supreme Court enunciated the principles that govern the grant or refusal of such injunctions. The Supreme Court there held that what was sought was an equitable relief, and like all equitable reliefs, it had to satisfy the tests laid down for the exercise of discretion. And broadly, these were the first principle that was laid down: 1, that the defendant was amenable to the jurisdiction of the court; 2, that the ends of justice would be defeated if the injunction was not granted; that 3, that the court must have regard to the principles of comity, that is to say, respect for the foreign jurisdiction whose proceeding was sought to be stayed; and 4, and this was most important, where both forums were available, the test of forum non-convenience would be the determinative factor. The court went on to lay down 6 other guiding principles that would be applicable in the determination of the grant or refusal of an anti-suit injunction. In the matter of forum non-convenience applications, the court seized the matter. I may be permitted a slight digression and anecdotal experiences my own, which Kshama you referred to. One was in the Southern District Court of New York, presided over by Justice Priso. I was asked to give evidence. The suit was by Standard Chartered by Citibank against Standard Chartered in the Indian court, and it was sought to be stayed on the ground that the Indian jurisdiction would be the proper jurisdiction. I was asked to give evidence as to the gestation period of a suit in the Bombay High Court. And I said it would be 10 to 15 years. When Justice Priso nearly fell out of his chair and said, "Did you say 10 to 15 years?" I said, "Regrettably so." And among the reasons given by me, one of them was that the gentleman who was to give evidence on the other side, Justice Bhagwati, was, with the best of intentions, largely responsible in having entertained letter petitions. And Justice Priso said, "Oh my God, don't tell me you're making the same mistake that we made in this country." That was one experience. And the other was in the suit in the Isle of Man court, where an affidavit evidence had been given by a former Chief Justice of India, who shall remain unnamed, where he said that a suit in the Bombay High Court would take no more than 4 to 5 years. I was asked whether I agreed with that, and I said, certainly not, and I have already given evidence to the contrary. They said, would you give an affidavit evidence, but you'll have to make it a very detailed and a very heavy affidavit. And I said, yes, I understand quite right. After all, the former Chief Justice of India has opined to the contrary, so you want me to do, as an ordinary lawyer, something which is contrary to what the Chief Justice has said. And I did give an affidavit to that effect that, again, 10 to 15 years was my estimate of a proceeding in the Bombay High Court. And, well, it led to rather to and fro, almost an unpleasant exchange of affidavits, where the former Chief Justice said he did not share Mr. Chagla's very pessimistic view. Just about at that time, there was a proceeding in the English court where Indian Hotels filed a non-convenience application in respect of a suit filed in England arising out of the 9/11 incident where the plaintiff had tried to climb out of the window of the Taj Mahal, had fallen and broken his leg. And he filed a suit for damages in England. And evidence was given, and a senior advocate of the Bombay High Court gave evidence to say that a suit in the Bombay High Court would take 4 years or 5 years. In the course of his judgment, the learned single judge said that I asked learned counsel who gave evidence whether this was based on some anecdotal evidence or was it merely his gut feeling. And the judge went on to record that the witness was driven to admit that it was only the latter, namely his gut feeling. I'm sorry, it's a bit of a digression, but I thought it might be interesting just to give an idea of how these matters do proceed in foreign jurisdictions where it's a matter of foreign non-convenience. But as I said, that is a matter where the foreign court is asked to determine whether it should continue with the proceeding or not, because the convenience is not, the forum is not convenient. Now, returning to Modi Enterprise, now there, the Supreme Court considered and applied the principles enunciated by the English courts. And Modi is considered today in India, continues to be the gold standard, and where all those principles have been applied. In England, the latest dissertation on the subject is to be found in Deutsche Bank. And one important distinction made there is between exclusive and non-exclusive clauses, something which was not dealt with in any great detail in Modi Enterprises. And the English court has cautioned against a tendency to equate non-exclusive with exclusive. It emphasizes that by its very nature, a non-exclusive clause contemplates parallel proceedings. And it is only when it can be shown that a proceeding commenced in a non-selected jurisdiction is oppressive or vexatious that it would be restrained. In other words, it is not oppressive or vexatious to adopt proceedings in a non-selected jurisdiction. That is to say that if it's a non-exclusive jurisdiction, parallel proceedings can go on. And therefore, by itself, to say that the non-exclusive jurisdiction should be that in London and England, and a suit is filed in India, it is not by itself an act of oppression or vexation to do that. The court would ultimately decide whether it is vexation or oppressive or not. Now, coming to anti-arbitration agreements, there the position is vastly different. The principles applicable to anti-suit are strictly not applicable to anti-arbitration injunctions. Here, the courts have adopted largely, and I think very rightly, a hands-off approach. The reason is not far to seek. Here, the principles of party autonomy and competence prevail. The court must and will exercise self-restraint in considering the grant or refusal of injunctions to restrain arbitration. This self-restraint, to my mind, is far stricter and of greater moment in anti-arbitration applications than it is in an anti-suit application. And here, as usual, it is the Delhi High Court that has taken the lead in this branch of the law so far as India is concerned. Anti-arbitration injunctions are sought in respect of both ordinary commercial arbitrations as also in pursuance of bilateral investment treaties or any other treaties for that matter. In ordinary commercial arbitrations, the court will have jurisdiction to determine whether the arbitration agreement is void or is a nullity. Under the New York Convention, unless it can be shown that the arbitration agreement is null and void, inoperative or incapable of being performed, no relief will be granted. In the McDonald's case, where a single judge of the Delhi High Court granted an injunction staying the arbitration which had been proceeding in England, the division bench set aside the injunction. The division bench clearly said that the power must be exercised rarely and on principles analogous to sections 8 and 45 of the 1996 Act, as the case may be. Equally, under the BIT arbitrations, while the inherent power of the court is not circumscribed in any manner, it is not and cannot be exercised except in the rarest of rare cases. That inherent power does extend to injuncting such arbitrations pursuant to investment treaties, but on the limited ground that the invocation or continuance is oppressive or vexatious in the particular facts of that case. But the emphasis is always on restraint, and when the arbitral tribunal has been formed, the court will leave it to the tribunal to decide all questions such as pleas of res judicata, etc. The court will not take it upon itself to decide those questions. The arbitral tribunal has been formed, therefore please go before the tribunal and ask the tribunal to decide these matters. It's all within their competence, within their jurisdiction, and they can decide those matters. My own personal view is an extremely strict view. Parties have chosen an alternate dispute mechanism. They have chosen the jurisdiction as to the seat of arbitration. They have chosen the governing law. The scope, to my mind, for judicial intervention must be restricted in the extreme. And it is only in the most extraordinary case that arbitration, whether commercial or pursuant to bilateral investment treaties, or for that matter, any other treaties, should not at all be interfered. That, I think, is my own view, and with that, I think I say that in conclusion of my statement. Now, you'll be shooting all sorts of questions at me, which I shall endeavor to answer.
Thank you so much, sir. That is an extremely interesting overview on the topic and on your experience, sir. So 55 years at the bar with many landmark judgments and, of course, Modi Entertainment on anti-suit injunctions in 2003 that continues to hold the field. Extremely creative arguments by you in this matter, sir, as a respondents' counsel. You did mention that the court laid out the principles where choice of forum came to be honored over natural jurisdiction of a court. So could we benefit from your view on how Modi Entertainment case changed the landscape on anti-suit injunctions in India after 2003?
I think the changing the landscape, what it really did was to, for the first time, as I said, it took till 2003 to lay down the guiding principles. There had been no real clear enunciation of the law before that. There had been more an ad hoc approach where injunctions were granted either anti-suit or anti-arbitration, but it had never been put in any proper form. But for the first time, those 7 guiding principles laid down by the Supreme Court, that's why I call them the gold standard today. And they were largely, of course, founded on what had been decided by the English courts. And the English courts had a number of judgments dealt with this rather interesting and rather exciting aspect of the law of private international law. So it changed the landscape it gave proper guidance for the future as to when a court would entertain such a application to restrain a suit, or, well, not an arbitration, but certainly a suit.
So one of the points that you earlier mentioned is regarding principles of comity. Now, any anti-suit injunction by its very nature is going to impinge upon the principles of comity or sovereignty of another state, because effectively you are saying that, or the court is saying that you cannot proceed in another court before in another state. So by its very nature, it's impinging upon this sovereignty and comity of courts. So how does one actually balance this with other sort of considerations that come in? And what is your take on this particular aspect as to balancing this issue with other things which come in or other factors which come in while granting of injunction?
Clearly, comity, the principle of comity, the respect for the other jurisdiction, extends to non-interference, except in very exceptional circumstances. Now, there are 2 aspects to it, and I'll deal with them separately. One is where there is no exclusive jurisdiction clause or non-exclusive clause, but it is based entirely on forum non-convenience. And where there, an extremely strong case has to be made out, because it's a parallel jurisdiction, and the comity, of course, would say that, well, if the cause of action is available in another jurisdiction, undoubtedly that will continue. But this is where it really arises only where there are exclusion clauses of jurisdiction, either with a non-exclusive or an exclusive jurisdiction clause. Now, in the case of as I mentioned earlier, in the case of a non-exclusive jurisdiction clause, it does contemplate 2 parallel proceedings, and therefore to adopt a proceeding in a court which is not the court of natural jurisdiction is not by itself oppressive or vexatious. Something more has to be shown, and it's only when that something more is shown that when a court would grant that relief. Of course, if it's a case of an exclusive jurisdiction, the matter is totally different, and that is where you have to go by what the parties have agreed. And if you confer exclusive jurisdiction, as they do jurisdiction in England, our entire jurisprudence is that you cannot by consent confer jurisdiction. England is to the contrary. You can confer jurisdiction, and in fact, a number of agreements do choose England as the jurisdictional clause, even though no part of the cause of action, the parties don't reside there. Nevertheless, they say that we have confidence in the English system, and therefore we will choose that as the forum to decide all our disputes.
Thank you, sir. Sir, you touched upon how anti-arbitration injunctions differ from anti-suit injunctions. We often face a situation when there is an arbitration agreement between the parties. Parties have agreed to a seat, and one party initiates proceedings in foreign court in breach of the arbitration agreement. Now, here, the seat court, which is the supervisory court for the arbitration, can restrain a party from proceeding in foreign court in breach of the arbitration agreement. What different considerations can a party plead before the seat court to restrain the other party from proceeding in a foreign court?
I think Kshama, I think when we speak of anti-arbitration injunctions, that is where you're seeking an injunction to restrain an arbitration. The example you're giving is one where in breach of the arbitration agreement. I think there the situation should be much simpler in getting such an injunction, because that's contrary to the clear agreement of the parties to go to alternate dispute resolution, and where a suit is filed contrary to such an arbitration agreement. Of course, again, we're talking in terms of a suit being filed in another jurisdiction, not in the same jurisdiction, because that otherwise you could almost seek stay in respect of a domestic arbitration, a domestic suit, because the matter is covered by an arbitration clause, and you would apply to the court hearing the matter. And why I say that the principles must be different is because arbitration is a consensual agreement. Parties have agreed to arbitration. Parties have agreed to that alternate dispute resolution, and therefore it is much weightier in saying that arbitration must proceed. In the case of an anti-suit injunction, an injunction is filed, a suit is filed without my consent, without in any way my being a party to it. And that is why the principles must be different, where it's an anti-suit injunction as against anti-arbitration. Arbitration proceeds on the basis that it is a consensual thing, and therefore, normally, and that's why I say I take a very strict view that there should be complete hands-off so far as arbitration is concerned. You've agreed to it, and therefore it's only in the most extraordinary case that you would seek and obtain an injunction restraining arbitration.
So, I think in India, especially, we see a lot of cases where we file proceedings in India, even though there are arbitration proceedings outside India. And nowadays, we see even scenarios where we have arbitrations in India and people are initiating proceedings outside India. Now, obviously, it's not always that you are defending the arbitration. Sometimes you do end up defending the foreign proceeding as well. So in those circumstances, how can one approach the issue, or in when does one really advise to say that even though somebody is trying to start an arbitration, this is a good circumstance to still start a foreign court proceeding?
Well, I think that's running counter to what my view is, in that if you have agreed to consensually to alternate dispute resolution, then to file a suit in breach of that agreement would be really, a court would not give its assistance to such a breach, but would possibly grant the injunction. So I don't know how, but that would be how a party could justify going to a foreign jurisdiction in a suit when in fact there is a clear arbitration agreement that binds the parties. Whether you get the injunction here or you get a stay of the suit in the foreign proceeding would again be dependent on that arbitration agreement, just as it is in a domestic one. If I file a suit in violation of an arbitration agreement, I clearly move the court and get it stayed, get the suit stayed, and have it referred to arbitration, because there is a binding arbitration agreement that covers the disputes in question.
So, the New York Convention also states that an award will not be enforced when it is not arbitrable in the country where enforcement is sought or violates public policy of that country. Now, most anti-arbitration injunctions are filed in courts where, if the party loses, enforcement would be sought in the country of the losing party, where the assets are located, of course. So, do you believe that it is better to seek an anti-arbitration injunction at the outset in the enforcing court, the potentially enforcing court, on grounds of arbitrability, or wait for the entire arbitration to proceed and wait for the arbitration award to assess if you can then challenge or try and set aside or object to the enforcement of the award on grounds of arbitrability and public policy?
In a matter of that nature, What you're really referring to is where you're seeking an injunction against an arbitration. I think, have I followed your question correctly?
Yes, sir.
So you're seeking an injunction, but that injunction can be granted under the New York Convention only if it is found that the agreement is null and void, or you make up that case, and the court is satisfied that it's not capable of performance. Then in that case alone, you would be able to get any relief. But therefore, if you are of the view and you have a case that the agreement is null and void, then by all means, it makes sense to initiate that action right at the outset, rather than wait for enforceability at the subsequent stage. And that is only on the ground that the agreement is null and void or incapable of performance. That's that limited.
Right. And so, when an anti-arbitration injunction is passed, restraining an arbitral tribunal from continuing arbitration proceedings, the arbitral tribunal is often in a dilemma to continue or stop proceedings. Several court orders granting these injunctions also purport to impose fines on parties if they continue with the arbitration. What is your view on this situation? Can arbitral tribunals continue with arbitration proceedings in contempt of such court orders?
I don't think the arbitral tribunal is in contempt. The injunction will be to restrain the party from proceeding with the arbitration and not against the arbitral tribunal. I think that would be the form of the injunction that you would obtain. So the arbitral tribunal is not within the jurisdiction of the court in which you are seeking the injunction, in which case the injunction can only be in personam, in respect of the party, and restraining the party from proceeding. The arbitral tribunal is in a foreign jurisdiction. It won't be subject to the jurisdiction of, say, the Bombay High Court or any Indian court. So I think the arbitral tribunal in proceeding does not commit contempt, but the parties certainly would be restrained. I think that would be the form of the injunction.
Possibly, yeah. So coming to one of the last questions around here that we have for you, and this one's slightly interesting. When something new that we now see, which is an anti-arbitration or an anti-suit, which is essentially saying that if you are going to initiate an anti-arbitration proceeding, I am going to start something to say it's you don't do and file that suit to get an anti-arbitration injunction. So what's been your experience, or have you seen that, or what is your view generally on such type of actions?
I'm always in a learning stage, even at this stage. I don't know of such anti injunctions which are either sought or obtained. But as I said, I'm always willing to learn. What is the basis of that? So you would say that if you can't file an anti-suit injunction against me from proceeding, it's like a quietemet action. That I anticipate and I believe that you're going to file a proceeding to stop me from continuing with my proceeding. Therefore, grant me an injunction restraining it. But that would be a restraint of legal proceedings, which to my mind is not permissible. You can't have an injunction to restrain legal proceedings.
So I think completely obviously appreciate your analysis on this and agree to that extent. But there in cases, and you are rightly saying, context of suit, that is exactly the case how it would be viewed. But in context of arbitrations, we have seen, at least in US and England context, there have been, at least to my recollection, one scenario where arbitration proceedings were going on in London. Somebody tried to commence simultaneous arbitration in US, and while commencing arbitration in US, they sought to restrain arbitration in England. And the English court went ahead and granted an anti-arbitration to that person's attempt in US to stop the English arbitration. So probably in context of arbitrations, yes. But as in context of suit, as you rightly pointed out in an Indian scenario, yes, that would be in proceeding trying to sort of restrain legal proceedings and therefore not entirely permissible.
Yeah. But it would all depend on the jurisdiction, whether such injunctions could be granted in England or in any other foreign jurisdiction, namely in restraint of legal proceedings. And that would be, I think, the distinction factor there.
I completely appreciate that, sir. And sitting out of Singapore, we do see these fine distinctions because, at least in context of anti-arbitration injunctions, and India sort of resembles the English approach, and English courts are sort of easy to grant, or they, as compared to Singapore courts, at least these anti-arbitration injunctions, deriving their power differently. Whereas Singapore saying that our law is completely based on the model law, and model law is premised on the principles of least court interference, and the principle of competence is even more supreme in under the model law as opposed to the English arbitration law. So Singapore courts, at least in our experience, has been that they are even slower in issuing these anti-arbitration injunctions as opposed to English courts. And obviously French courts completely don't, and they completely refrain from issuing any such anti-arbitration injunction. So as you rightly point out, jurisdictions do make a difference, and India obviously as a legacy matter tends to follow England on this.
Well, I'm glad I'm in good company in Singapore and France in saying such injunctions ought not to be granted and are not granted in those jurisdictions. That's my view, and I think that's a view which ought to be accepted in India as well. And I think we'll have to wait for another Modi entertainment to decide that question by the Supreme Court. And unfortunately, as there has been an anti-suit injunction, there has not been, in respect of anti-arbitration, any final determinative judgment of the Supreme Court. And we must await that to lay down those principles. Whether they follow the English model or the Singapore model or the French model is a moot question, and it should lead to a very healthy debate in the Supreme Court, and hopefully result in a very good judgment from the Supreme Court as well.
Thank you, sir. So what is your view on anti-BIT arbitration injunctions, anti-bilateral investment treaty arbitration injunctions? You touched upon this in your opening remarks. We were just wondering if there are any different or special considerations or a more hands-off approach towards investment treaty arbitrations where courts must not interfere. What are these special considerations?
Again, it's the consensual aspect of the matter. And where again, unless there is an overwhelming case where it is of vexatious proceeding or an oppressive proceeding, the court will not interfere even in respect of such treaty obligations and arbitrations under the BIT regime. And in my view, rightly so. Therefore, even in respect of whether it's a commercial arbitration or a treaty arbitration, the principles broadly are the same.
Right. And so there's also an added layer probably in investment treaty arbitrations where a state cannot take recourse to its internal law in order to excuse itself from international obligations. So probably that's one more element that comes in an investment treaty arbitration. With that, our questions to you are complete, sir, but we do have some questions from our participants. I have a question here from Gaurav. Gaurav has said, sir, as you indicated, where the jurisdiction clause is non-exclusive, parallel proceedings can take place. An injunction would follow only if proceedings are vexatious. In an exclusive jurisdiction clause, would choice of law matter, or what would be the other considerations other than the matter just being vexatious when there is an exclusive jurisdiction clause that the parties have agreed to?
No, where there is an exclusive jurisdiction clause, then I think clearly an injunction would be granted because parties have chosen exclusively to go to the jurisdiction of a particular court. And if the court assumes that parties have considered that to be a forum convenience, that it is not inconvenient, and that therefore the court would not and should not interfere in such matters. So that's where the exclusive jurisdiction. It's only in non-exclusive jurisdiction that a parallel proceeding can be filed. In an exclusive jurisdiction, you just can't do it. Either you would get a stay if it was, say, Indian court where a proceeding started, or you would get an injunction in the foreign jurisdiction to restrain the Indian proceeding if you've agreed upon an exclusive jurisdictional clause saying that England alone will have jurisdiction.
Thank you, sir. There's a question from Ruchir. Can an arbitral tribunal pass an anti-suit injunction? This was also one of the topics that Ashish and I were discussing. If we could ask you a question on this, sir. Can an arbitral tribunal pass an anti-suit injunction, and what is the efficacy of such an order from the tribunal?
I think it would be a very courageous arbitral tribunal before whom such an application would be made and which would be entertained and would be granted. What is the jurisdiction of an arbitral tribunal to restrain legal proceedings in a court of law? An arbitration is a private proceeding. It's something which can't even be referred to outside. It can't be. It has no other. It is entirely a consensual proceeding which continues. But therefore, the jurisdiction of the arbitral tribunal is confined to deciding the disputes covered by the arbitration clause. But to make an application to the tribunal to restrain a legal proceeding, as I said, it's not really courageous, and if the arbitral tribunal were to grant it, it would be highly remarked upon, to put it very mildly.
And the final question, sir, and this relates again to our question on, or Ashish's question to you on, can arbitral tribunals continue with arbitration proceedings in contempt of court orders? The question is, can, when an arbitral tribunal is seated in the country where the courts have actually passed an order trying to restrain the tribunal from continuing the arbitration, are there any modes that an arbitral tribunal can adopt, especially in an uncitral arbitration, to sort of protect itself from such court orders?
No, I'm sorry, I'm not quite following. This would be an injunction granted by a court where the arbitral tribunal is seated.
Yes.
Where the seat of arbitration.
That's
no court would grant such an injunction. You would then apply for stay. It would not be of the arbitration, various grounds. And if there is such a stay, then unquestionably the arbitral tribunal would not continue because it is within the jurisdiction of that particular court.
Right. And just to add on to that question, there was in fact a case of, if I recall correctly, Himparna versus PLN Indonesia, wherein the arbitral tribunal was to be seated in Indonesia, but since it was an uncitral arbitration and PLN Indonesia sought an anti-arbitration injunction from the court, the arbitral tribunal, as Sir mentioned, courageously moved the arbitration away from Indonesia, held it in London or in Paris, because it was an uncitral arbitration, and continued with the award. In this way, it could actually escape from the force of the Indonesian court orders. And if I recall correctly, the argument or the argument that the tribunal made was that it is a creature of the contract and does not derive its power from any sovereign country or court, so it could go ahead with the arbitration. If that answers your question, I believe it was Akanksha's question.
So, Kshama, just to add, yeah.
Yes,
Sorry, go ahead. So just to add there, whilst the arbitral tribunal made a courageous decision, and I don't know who the members are, but probably my guess is from a civil law jurisdiction. Because if the seat was in Indonesia, then obviously the tribunal would be subject to the supervisory jurisdiction of the Indonesian courts.
Exactly.
And therefore, if the award is set aside because the award was in violation of the seat orders, then effectively under New York Convention, there could be a bar against enforcement of an award set aside at the seat court itself in foreign countries. The tribunal
Absolutely.
proceeding, despite the seat court orders, generally would seem an anomaly, and probably obviously the case is there. But as I said, that my guess would be the tribunal came from a civil law jurisdiction who possibly sometimes allow enforcement of awards irrespective of their treatment at the seat court. So
Absolutely, because they consider that they are delocalized. So,
The
yes.
ingenuity of an arbitral tribunal in leaving the seat and holding the arbitration and saying, therefore, we are not bound, it makes no sense at all.
Yes, yes.
It makes no sense.
Right. And we have one last question, sir, before we move to the closing. Where a party has specified that a matter of X nature will be referred to arbitral tribunal and a matter other than that specified nature is submitted, I believe the question is incomplete, can an anti-arbitration injunction be passed, or will it be subject to the powers under Section 16 of the Arbitration and Conciliation Act?
No, any such application made to the court would meet with the fate that it is for the arbitral tribunal to decide its own jurisdiction. And therefore, if the dispute is beyond the terms of reference and does not fall within the arbitration clause, that is a matter which should be argued before the arbitral tribunal. And the decision, of course, of the arbitral tribunal will ultimately be subject to Section 34 proceedings. But it would be, no court would interfere. It would be left to the arbitral tribunal to decide it.
Thank you so much, sir. Mozam, would you like to say something? We're coming to the end of the session now.
I think, wow, what an interesting discussion. Firstly, some of the little droplets of knowledge that came in were fantastic. But in fact, one of the questions that Kshama you asked, and then Ashish followed on that question with his own twist, actually reminded me of one of my experiences about 10 years ago, wherein one of our clients had to approach the UK Commercial Court Queen's Bench Division to say two things, or rather three things. One, we want to start an arbitration which was London seated. Two, that in India, defendant is most likely going to file a suit. And three, that if the defendant doesn't file a suit, he is most likely going to seek an anti-arbitration injunction. And we followed up by saying that Indian courts at that time were actually exercising jurisdiction, or were actually entertaining these matters, and the disputes would often go on for a couple of years, or much more actually than that, before Indian courts would come to a final decision, even if that final decision is that we don't have jurisdiction because there's an arbitration clause. But you still end up losing, a couple of years in the process. And therefore, give me an anti-arbitration injunction and an anti-suit injunction. And in fact, we also, just like in Sir's experience, we had filed an expert evidence of one of our Indian legal luminaries. And UK court was, the Queen's Bench Division was very, very quick to grant an ex parte anti-suit injunction and an anti-arbitration injunction, basis that, well, the flip side is that the other side never questioned it. So everything went smoothly from there on. They actually said that we never intended to file a suit. So we're okay with the injunction.
You played safe.
On principle, I think what you're really referring to is a proceeding which is filed or which was restrained by the English court, or was it a preemptive strike? In that
it was a preemptive strike, sir. It was a preemptive strike.
Which is really prohibiting the adoption of legal proceeding, which I find is a little difficult. Now, if it's a matter of comity, then surely the respect that you owe to the other court.
You're
absolutely the other court will not entertain such a suit and will not entertain such an application. That would be. It actually
hits the principle that you mentioned. It's actually restraining someone from initiating legal proceedings. And also, I mean, there is another question on, whether an injunction which is granted by a UK court can actually be enforced in India, and all those technical aspects then kick in. But again, maybe that's for another discussion, another time. But thank you so much, sir. I frankly, first and foremost, wanted to thank you for being to speak on this panel alongside my colleagues today, and if I may say, allowing us to bask in the glory of your presence and knowledge. And from all of us at NDA, sir, and probably hundreds of those who joined on the WebEx, and possibly hundreds more who will in future see the recordings once they go live on TV, on Nishith TV, are forever grateful. And in fact, my only grievance is that this little 1 hour time slot was probably too short to even, scratch the surface of the mountain of knowledge that resides within you. And I, along with my colleagues, will, of course, look forward to the next time that we have you over in our one of these cCep programs, and possibly, delve a little deeper in some of those topics that we discussed today, and hopefully some new ones as well. So thank you so much.
Thank you all very, very much. And Nishith, thank you so much for allowing me this experience of talking to you. And speaking for myself, I've found it most invigorating in the lockdown, where in this isolation, it's given me something to read, to look up, and to do a little rumination. And then grey cells are getting terribly otherwise inactive. And so it's been a good experience. Thank you all.
Thank you very much. Thank you very much, Iqbal. I think this lockdown has also unlocked our virtual potential, and we are now able to find how much we can do even if you're locked down, Yeah. And you are always so eloquent, and you explain most complex thing in simplest possible words to all of us. I think at my age, I always learn from you, and you can see also all my juniors, they ask so many detailed questions, and I have to deal with them. You can imagine my plight, But
very fortunate in having them, Nishith.
They keep us sharpened all the time, And I'm sure all the people from all over who have been listening to have been greatly benefited from this conversation. And I hope we can continue from time to time taking some of this kind of interactions now that we are connected in the virtual world. I think it allows us to do so many things, and which you never imagined, And I think especially now that you can't travel much, you cannot do everything. It also teaches us that we are doing so much unnecessary travel, And hopefully even Supreme Court and other courts will go for e-litigation, hopefully without traveling frequently and to Delhi or anywhere else. We'll be able to do so much. And your decision of staying back home in Mumbai, I think, would not, have any problem any longer, So,
well, I'm now not looking forward. I'm looking backward, Nishith. Having crossed a magic figure of 80, I think now the time has come to put my feet up and relax a little and do all the things that I wanted to do all this time. So that's the other aspect of the matter.
And thank you so much. And I also am a member of a US club, and I remember you also had taken up some issues in the past. And
yes, I know.
So let's stay connected, and really appreciate once again your coming on this WebEx and giving your insight to the whole world. It's going to be continuing. It will be repeated sometime also on our. We have created Nishith.tv, so that people can also go back and listen to the recording anytime. And it's not completely educational. It's mainly for education, So
Okay.
yeah, so I think all the students and professionals and client community and everybody continuously access them. But hope to catch up with you personally as well once this lockdown is over.
Yes,
Thank you.
I look forward to that.
It's so nice of you, and let's close this. So thank you so much.